June this year, work was done, because once the monsoon starts, it's simply impossible to do anything. So till June, we had gone and seen, and out of 332 kilometers, most of the work was done, except for about 60 to 70 kilometers where work was pending. Now, I must also say that there are certain issues which kept coming up, such as permission from the forest department for forest areas, materials being sourced from the quarries over here. There were various issues, but they were being dealt with by the administration and NH, and the court was monitoring the situation. Now, there were deadlines given for the work to be done. January 30th, certain things were done, certain things were not. Then March 31st, May 30th, like this, it continued. Ultimately, in June, when the work was not done, the bench had kept this matter part-heard and had taken the file to Calcutta. So the bench passed an order imposing a cost of 100 crores on NH, cost in terms of every kilometer that was there. We calculated how much the expense was. So towards that amount had to be deposited. Challenging that order, NH went to the Supreme Court. The Supreme Court was pleased to stay only that portion, the 100 crores cost, and direct the matter to come up for hearing. In the meantime, NH was asked to give a strategy of what they plan to do and the time frame in which they wish to do it. Unfortunately, in the Supreme Court, the matter could not be taken. As per my instruction, what we found out, it will be coming only in the month of November or so. Now, between June and November, there has been incessant rain. And the rains in Andamans are quite serious, Your Lordship is aware. Now, what has happened is there are certain parts of the road where work was never done. That is Baratang, Rangat, that area, between kilometers 107 to about 180. Those areas work had not been done, and those areas have gone into a very bad situation. Certain other areas, surprisingly, where the work was done and we have inspected and found the work to be done well, those areas have collapsed. The road has washed away. Now, we cannot yet reconcile, both of us, what we saw in June, where roads were actually very, very good, with a situation now where we get instructions from there that the road is just gone. Now, in this situation, two circuits had come. So the first circuit which came, that was Madam Justice Tandon. No, I'm sorry, before that, Amrita Sinha. Madam Justice Amrita Sinha's bench. Their lordships had passed certain orders. Now, in the meantime, what happened is, because of very heavy rain, there was severe waterlogging in certain areas. The drainage work and all was not done. There was waterlogging. So for those, we had some hearings, and the NH had apprised the court what is the problem. The APWD engineers had gone there. They also saw the situation. Those emergency situations have been rectified. So water is now not collecting, and now with the rains not stopping, that's not an issue. This was number one. Number two was, thereafter, my Lord Justice Tandon's bench had come. In that point of time, the road situation had worsened even more. So this is a lifeline for Diglipur and Maibandar and all people to come here. It is otherwise absolutely impossible, because helicopter is not always available. Ships depend on the weather, things like that. So Justice Tandon passed some orders for immediate measures to be taken, whatever is possible, given that in the middle of heavy monsoon, you can't do the work. But his lordship said, at least let the road be motorable. Keep a surface, even if it's not a proper blacktop, something that vehicles can move. Now, after his lordships had left, I have been apprised of certain situations, which is why there is a bit of an urgency, which is why we mentioned the matter, asking for your lordships to look at the situation once more. First of all, if your lordships would just have a look at this. I have circulated this to my learned friends. They are aware of this. So this is the situation of the road in certain parts. I mean, we cannot even gratify it with the name road. It has just become a mud track. There have been certain accidents. There have been certain incidents. In addition to this, there are three problems. On the last occasion, Mr. Rakesh Pal Govind, who is the secretary of the Bar Association, even he had filed an affidavit before Justice Tandon, because he was going to Maibandar and he had some incident with his vehicle also. So it is no one's disputing the fact that it's very, very bad. Now, this came to us a few days back. Because of this, there is also a potential law and order problem, because the local people who are there, not everyone is driving like a tourist from Port Blair to Diglipur. People live there. So just to go from your house to a school or an office or whatever, you have to use the same road. And number three, what is the urgent situation? As I understand, my lord, I was given this by this was sent to me by a elected representative in the north and middle. I'm sorry, my lord, I have only one copy. Indian Oil Corporation, which sends fuel to the north in those big tanker trucks, which carry about 60 kiloliters of fuel, their vehicles have had accidents, incidents, and they have now informed the administration that it is becoming dangerous to send those tankers, because if one tanker slips off the road or skids off the road with that highly flammable thing, it may be a serious problem. Now, thereafter, it was publicized in the local media as well. IOCL has said beyond Baratang and Rangat, we are not being able to send fuel. And I have received instruction personally from people in Diglipur and Mayabandar that there are massive lines in the petrol pumps as a fuel shortage. And if your lordship considers, there are also two other aspects. One is that everything there, electricity, is run by generators most of the time. So if you don't have fuel, you can potentially plunge the area into darkness. Second problem is now the tourist season would be starting from November. So again, all the tourist activities, boats, everything depends on fuel. So fuel is something which is like a essential commodity, which is a lifeline. So in light of this situation, my lord, we felt as the special officers of the court, since we are not appearing for any party, we felt it was necessary to apprise the court that this situation this has come. Because now how the administration plans to deal with it, how things can be done, those are matters of policy. But since this court has felt the need to continue monitoring the situation, it may be necessary for the NH and EPWD to now look at the situation.
Immediate steps.
Immediate steps.
Let us hear. Yes, what is your suggestion, sir?
Just to what has happened. Since the last occasion, there was an immediate issue of water logging. That issue has been addressed because we have installed pipes. To that effect, we'll submit a report afterwards. Now, the emergent issue which Mr. Kumar and Mr. Kabir has informed me, they have circulated the pictures. We have also taken that. In that 22 stretches, at risks and cost, the work has started. Now, what we are looking forward, at least one lane should be open because this is a very urgent issue. Otherwise, North will be completely cut off.
Yes.
So these thing, only one issue that we are facing, that is the stone aggregates. Now, queries has been handed over by the administration. There were certain issues with, probably with the Green Tribunal that we don't know. The administration can, assist your lordship on that. But what I was informed that in North Andaman and in Middle Andaman, the queries has been given. Now, the problem is, the stone aggregates that we procure from there is not, well enough to, give this support. Because we are not looking forward for a temporary measure. So we do it today, again tomorrow it is washed off or it is kind of broken. So we are looking forward for a permanent measure. So for that, South Andaman queries are required. The kind of boulders that we need and 10,000 cubic meter, as I was informed, is the essential requirement. Now, one thing that I was also, before your lordship's, was, we had a discussion. I was having a discussion with Mr. Kumar and Mr. Kabir that, EPWD and, the other organizations, they have their own stone queries. Now, if an arrangement can be made, if a meeting can be held between the parties, because this is an emergent issue, we take the queries, we take the aggregates, so soon the queries are handed over to us, we'll return them back. This is a measure that it will address immediately, so that at least one lane can be kept operable till such time the other queries come and we can fix the problem permanently. If that kind of a, though they had a meeting, which I was informed, there was a meeting held between
requisition the stone queries.
We have written to the administration for handing over the queries. They have handed over in North Andaman. The quality of stone aggregate
is not up to the mark.
Not up to the mark. So, these South Andaman queries are basically previously also, because we need to kind of build and structure that will hold the entire road. Now, if the boulders are brittle or they are kind of they disintegrate fast, that will not serve the purpose. We need something which will hold the base so that on top of that, if we construct the blacktop, it will hold, it will retain. So this is what we are looking for. And I was informed that South Andaman queries, they supposedly gives the best stone aggregates. So, and I was also informed this administration and other authorities, they have their own stone shortage. Now, they will also have to look because they have their own roads to be maintained. The APWD and other organizations, they have their own roads to maintain. Apart from that, we are running short of 10,000 cubic meter of stone quarries. Our contractors, since now we don't have that.
But this is time consuming, isn't it?
No, my lord,
What is the immediate step that? you
immediate
thought
step is
about?
if they hold a meeting immediately, if your lordship so direct, all the organizations, they can sit together, because most of the organizations are not parties before your lordship. Now, my lord, if through administration, my lord, this
So
can be
the
worked out.
direction was given by the earlier circuit also.
Yes, my lord, kindly sees the meeting that we had. So, my lord,
And a stopgap measure was also suggested by the court.
yes, stopgap
So
measure
that
was
has also
suggested.
not been done.
No, my lord, that was also, my lord, subject to correction, my lord, that there was another issue of water logging. That water was in excess, my lord, it was running into the locality, since there was an allegation that there has been some blockage over there on the bridge. Now, my lord, there was a meeting held on 10th of October 2023 with the engineers of the administration NHIDCL. No, my lord, it will be a submission from the bar, because I, my lord, couldn't prepare a report because I got the papers. Those, my lord, has taken into consideration those diversions, water logging, and the pipelines which has been constructed. My lord, the administration and NHIDCL has, my lord, come to a consensus in those regards. Now, my lord, so far as the stone queries are required, my lord, if there can be an immediate meeting held through administration, like if we can take the issue forward, and if we procure, means it will be an undertaking on our part, if so required, that immediately when the stone queries are handed over to us, we will return it back. My lord, I will only, my lord, give a gist to your lordship, like what has happened and which queries has been given to us. My lord,
Will you come back with a detailed report tomorrow? Because this should be on record.
My lord, may I just intervene for a moment? All throughout the situation has been, there's NH, there's APWD, there's Forest Department, there are contractors. This court said, we are not getting into nitty-gritties of the matter. You are NH, you have given the job to your contractors. Your contractors are to source material, get permission, do what they like. We are not entering into these issues because the court will not get into how agreements are to be done, where you will. In fact, it fell from the bench on the last occasion. If your contractors don't have material here, there is a shortage, National Green Tribunal is there. These things don't concern us. You have a job from 2016 to make the road. Now, how you do it is up to you. You get material from mainland, you get it from anywhere. It has to be done. Now, today, I understand my learned friend is looking for a practical solution, because a solution has to be worked out. But to what extent the court is going to be
A party to.
this, I have some reservation, because the court has been monitoring the situation, trying to provide that impetus to everyone. But today, now this meeting is held, everything is done. It is a matter of policy. If the administration says we do not want to give it, then does that mean the road will not be there? Now, we cannot, your lordship would not pass in mandamus
There
perhaps.
was a very clear direction on the other.
yes, my lord, but
but
that
earlier
lordship will kindly consider, my lord.
Even as a stopgap measure, immediate steps were required to be taken. That has not been done.
Yes, yes, that has been done. That was, lordship will kindly appreciate. That was with regard to the immediate issue of water logging and.
No, water logging was settled already.
Yes.
Water logging was
That
different.
is in fact no longer an issue. Now the rain has stopped.
Yes, repairing roads, my lord.
And making it motorable.
Yes, yes, that work has already been initiated. They are working and risk cost tender, my lord. There are 6 channels, like they are working now. Now, my lord, what we say on the last occasion also we submitted, like the kind of quantity of aggregates that we have.
Have you taken it up with the administration?
Yes, my lord, that issue, my lord, letters has been written. Pursuant to those, my lord, they have handed over. We say that certain queries has been handed over, but those are not, my lord, the quality that we are looking for. So, my lord, for this time being, my lord, if definitely, my lord, by tomorrow we'll file the report, like as to what has happened up to date. But, my lord, we'll kindly consider, my lord, if in the meantime, because, my lord, that which we need to make this, because that issue of IOC is what is, my lord, striking all of us all together. And, my lord, at least a portion of the road, if it can be made motorable, keeping aside the other works as it is going on, certain tenders has been cancelled, new tenders has been floated, new contractors has come in, that portion, leaving it aside, at least the contractors, those who are working at risk cost, if they can make one portion motorable, so that there can be a traffic blockade and, my lord, the IOC vehicles can move, the other vehicles can come. This is
How
what,
much time do you require for making at least one portion of the road motorable?
Malad, that specific instruction, because
That part is not cut out totally.
yes, Malad, that is channel.
Especially the IOC issue is it's very important
Yes, Malad, that is,
and it's very threatening also.
yes, that is in package 3. That will be. The pictures you are sending us.
The Baratang Rangat.
Baratang and Rangat.
Baratang. That is all between kilometers 107 to 182.
That's the worst part.
That is the worst. That is why no work has ever been done. So it goes from bad
That is
to
an
worse to
admitted fact.
critical.
Because that was, since there was no black topping, there was no embankment on the sides, Malad, there was an erosion.
And now it's not a road at all.
At all, when we have seen the pictures, and
only a
those are
mud
very
spot.
alarming. Those are very,
Yes.
and that is why, Malad, we have before your lordship today. Now, Malad, I will take a specific instructions with regard to, Malad, what time is required,
When can you make the earliest that you can make the road motorable?
and lordship will also consider
At
our.
least a stretch of it through which the vehicles can fly.
That is what we are, Malad, working on. We will, Malad, tomorrow we'll give your lordship a timeline by which, Malad, at least one lane is
Yes,
constructed.
more than a report, the timeline is required.
Timeline
And
is
you have to
required.
adhere to it.
Yes,
It's
No,
not
Malad-
only that you theoretically give a timeline and
I
then
tell you, lordship, Malad, certain times it is also an admitted position. We have filed dates, but we have missed those. Now, Malad, there are certain other issues. Definitely, I'm not going to, Malad, take the court into those kinds of, Malad, the issues that we face. It is our work. It has to be done. That we appreciate, Malad, that we are doing. Now, Malad, what has happened, Malad, we have taken into consideration that this will be the dry period where we can do the work. Certainly, Malad, the onset of monsoon, and it was prolonged. And this time, Malad, we have witnessed that this backwater flow. And that's why, Malad, a certain portion of work was kind of delayed. Those things were not taken into account. But as on date, for this portion, Malad, we can come back to your lordship, Malad, with a definite timeline. That this portion in such and such period we can do. And lordship will also consider, Malad, in the meantime, only with regard to these quarry materials, only with regard to the aggregate materials, Malad, if we can have a specific meeting in this regard. And if others, because this is, I
now
can't,
the court will not give a direction for a meeting.
my lord,
You can take up the matter with the administration and deal with it.
my lord.
The problem with the query is that there is a case going on in the NGT. Some person has filed a case to say illegal mining is going on. We have given report in that case as well. No matter the query is that over here there is a different types of query materials, and there are reports from Kharagpur University or Yadarpur, something like that. They came over here, they made inspection and give us report that from this query this much only can be extractable. From this query this much only extractable. Basic upon that we give queries and all. There are other litigations in regard to query materials are going on, madam, between the private parties and the administration. So it will be difficult, madam, and this query thing has been raised in the previous circuit also. When Justice Harish Chandra has directed that whether you can bring queries from the mainland, it's not a problem.
Well, that is not,
It will going to raise the cost, but it's not like that in mainland queries are not available.
well, bringing the queries from the mainland.
Cost is secondary to the
Secondary to the
life of
human
life and.
Yes, absolutely, my lord, but we have, because our office over here doesn't, my lord, but then again, my lord, that proposal has to be sent. This will again, my lord will appreciate this ministerial level. It again will drag the proceeding further. What we need to see, my lord, how immediate and how fast we can address the issue. So that, my lord, for the time being, at least the North Andaman is not cut off. That is what is, my lord, going on with our head. Now, my lord, these kind of administrative measures, it takes, my lord, will appreciate that it takes further more time.
And otherwise query will going to take time because tender will be issued.
No, that is why, my lord, that is why, because all some
What is
organizations.
the immediate?
Immediate is, my lord,
effect
that
that
is
you
what
can
we
do?
have to look for the avenues that is, my lord, emerged from our discussion, in-house discussion, that the organizations, they have their own aggregates. Now, if we can, my lord, if I may use the term loan, the
Now, looking for
aggregates.
avenues is, we've left that part, I think. We have to.
yes, that is why.
Put it into effect.
Effect. So if they for the timing, as I mentioned, this is what a rough calculation has come up to that 10,000 cubic meter of boulders are required. Now, if we get it, procure it, and so soon
If it is required, you have to procure it
Yes,
by any means.
by any means, that is So Lordship, that
Because there the court cannot help you out.
However, motorable road, with my understanding, does not mean you have to make a road with a glass. Motorable road means that you have to make some road, some
Pliable.
that at least a car can go over, a car or bus or truck, or people can move from that.
No, Leonard,
they have
Counsel
to
said
set a
we look for a permanent solution, but
Yes,
the
because
condition of the
it-
road is now.
solution is not possible.
Permanent solution.
It is not possible. It starts.
It's not possible.
No, no,
It takes
no,
some time.
no,
It will take
this
some
work can't be done now. In this rainy season, it can't be done. Permanent work has to start from November or
There's
December.
some kind of a,
That is
I
why-
don't want to use the term patchwork, but
exactly.
there is some
Exactly.
temporary
Now,
arrangement.
again, we'll have to come before your Lordship, because after certain times with the trucks and heavy vehicles moving, it will be again eroded. Then
No,
again, we'll have to
continue
come
with
before
your
your Lordship.
permanent solution, we are not stopping you, but then please go ahead.
That is-
with
that is
some
what-
temporary solution at
Absolutely.
the moment.
We, my lord, I'm not using the word, my lord, temporary, but we will look into this, and my lord will come back before your Lordship. We'll have it, we are holding
Looking into
meeting.
this is not sufficient, sir.
No, means looking into this
Please
means,
do something.
yes,
Please do something.
at least
One stretch should be made motorable in the shortest possible.
shortest possible time.
What is that shortest possible
That
time
will
that you're
come back.
seeking?
Yes.
Let him come back tomorrow with this. You are the special officers, isn't it?
No, both of us.
The special officers, learned counsels, Mr. Kumar and Mr. Kabir, apprises us of the fact that the stretch of road between Baratang and
This
Rangat,
would be covering Baratang and Rangat.
between Baratang and Rangat is deplorable to the extent that it cannot be termed as a road at all. Stop. The photographs placed before us indicate that the roads have been converted into a mud stretch, which is extremely dangerous for plying of vehicles. Stop. Moreover, the learned counsels has placed a letter issued by the Indian Oil Corporation Limited to the Deputy Commissioner, North and Middle Andamans on 9th October 2023, which states that the only connecting road between the terminal of the Indian Oil Corporation and North and Middle Andaman has deteriorated and has become unsafe for transportation of petroleum products. And it may not be feasible to arrange for immediate response to any spillage or accident that may occur due to the bad road condition. The letter, the corporation apprehends that supply of petroleum products can be maintained to North and Middle Andamans only upon immediate repair of the roads. Stop. Learned counsel for the, it's NHIDCL.
Yes.
NHIDCL submits that the authority is taking all necessary steps to arrive at a permanent solution with regard to repairing the road in question. Stop. Learned counsel admits that at least a portion / stretch of the road needs to be repaired immediately in order to bring it to motorable condition. Will you come back tomorrow? Submits. Okay, instead of admits, make it submits. Learned Counsel seeks to come back with definite instructions as to the time required for making the road pliable for the present. Yes? Tomorrow? Paragraph, so please come back tomorrow. Let the matter appear under the same heading tomorrow, that is on 18th.
Great.
I would request you to come back with a definite solution. Yes, give him.
Deep.
Yes, it will. To be mentioned first matter tomorrow. Next.
I have brought that judgment of this court while admitting the appeal as well as allowing the second appeal. This court held, my lord, if during the pendency of appeal, the party dies, appellant dies, and the fact is not brought to the notice of the court and a judgment is rendered, it's non-est. These are the appeal was, Lord would find in this order, admission, the substantial question is reproduced and the finding. And the matter was remanded back to the district court, it's pending. Lord can find at paragraph 2. This first substantial question of law, so far as the present appeal is concerned.
And then the appeal is decided on.
Decided, it was set aside, remanded back, giving liberty to the appellant to take out the substitution along with order 22 rule line application, setting aside abatement. And it's pending for consideration before the district judge. So this is my first substantial question so far as the present appeal is concerned, because the law is, if before hearing of the appeal, appellant dies, then it abates. In a dead man file, no judgment can be passed. Would find I have brought this compilation, plaint, written statement, and other material for the consideration of this court.
That's your only ground?
Well, that's one of the ground. I'll just show you. That's one of the ground. The other grounds are, my lord. The other ground is. The other ground is, my lord, there is a misapplication of regulation 148 in deciding the list by the first appellate court. My lord, 148 needs to be seen. Not my specific case, which would be evident from the written statement, is that Schedule 1 comprised of 2 landed properties. Well, I'll file their plaint. One is at Phoenix Bay, Mauja. The other is at Humphreyganj. So far as Humphreyganj property is concerned, we have accepted it. It's amenable to partition. But so far as Phoenix Bay property is concerned, it can't be partitioned because it was allotted independently by the government in the name of my deceased father. And my father died, it is recorded in my name. Exhibit D is the license. Exhibit A is the recommendation of the administration recommending the name of my father to give license, which was approved by Lieutenant Governor. This aspect was missed. Rather, the first appellate court as well as the trial court on the premise of 148. 148 has a different manner of application. Not kindly have a look to regulation 148 once. It is, it applies only when a tenant, recorded tenant dies and subject to the personal law, the modes of acquisition comes in 148. It's devolution, deals with devolution.
Yes,
My lord, my father died, who was conferred with the allotment license, coupled with license. Upon his death, I am the owner. Recorded has been done
the others are the brothers and sisters of the.
of my father,
Yes.
of my father. So, my lord, the first appellate court held devolution comes into. It's not the case. Because so far as the licensed property is concerned, already I have devolved it. It's in my name. But so far as the property which was given, whether which was owned by my grandfather, M.M. Shah, in respect of Humphrey's property, to that extent, inheritance succession already opened. Everybody is liable to get legal shares. So the first appellate court and the trial court went wrong here. Now, thirdly, the trial court held, and the first appellate court has endorsed as a whole, saying that not the schedule 1, that's Phoenix Bay Moja property, is an integral part of licensed land. There was no prayer made, there's no finding there's no decree being granted by the trial court. The first appellate court went beyond the pleading. So mainly on these 3 substantial ground, the appeal needs to be heard out loud. But I have paginated it, left-hand margin, circle page. There are several pagination at the top. For this purpose, I have paginated in the left-hand margin within the circle. Those needs to be seen. The first document is the plain, and not kindly see the schedule. Schedule is at page.
No, it's clear.
My lord, my lord. Lord, the first appellate court is swayed by this term khasra. Now, khasra under the local regulation is not a record entry. It's merely a field measurement book. Yes, absolutely.
Khasra means draft.
Yes, record entry is one thing, khasra is other thing. But the first appellate court has given credence to this khasra over and above my license. License is well recognized under the regulation, but khasra is not. It's for a limited purpose. Who is in possession? Encroachers occupying a land. Well, this factum would be mentioned in the khasra. If I am a government encroacher, my name would be recorded as in the khasra, field measurement book based on the ground level. So the first appellate court has completely misinterpreted this term khasra, because Exhibit 12 was before the trial court as khasra register. It's part of the compilation which I've given just now. Not kindly see the caption, it's khasra. And I'll take one of the regulation where the khasra is dealt with. May I take one of the khasra's definition?
Not necessary. Let it be admitted.
No.
Second appeal. Challenges the judgment and decree of the learned trial court as well as the first appellate court. Primarily on twofold grounds. Stop. Firstly, during pendency of the appeal, the first appellant expired and the decree was passed in favor of a dead person, comma, which is invalid in law. Stop. Secondly, comma, though the property There's just one schedule.
Schedule 1 comprises 2 properties. My lord, kindly come to schedule 1, Roman 1. One is of Mauja Phoenix Bay, the number 1. The other is of Humphreyganj village.
So with Humphreyganj, you have no.
I have no
schedule.
problem. It's amenable to the partition, Worship. I've accepted it right from the trial court.
Secondly, though the property situated at Humphreyganj, Ferrarganj Tehsil is amenable to partition among all the legal heirs of the erstwhile owner, comma, the property situated at Phoenix Bay, comma, Port Blair was allotted in favor of the father of the which appellant?
Present only one appellant. Present appellant, one appellant.
Father of the appellant
No.
by way of a license by the administration and could not have been included in the same schedule for partition. Stop. The said property, comma, in fact, comma, has been inherited solely by the appellant as the sole heir of the erstwhile licensee. That is your plea.
Yes, ma'am. Yes.
Paragraph. Upon consideration of the submission made on behalf of the appellant, comma, we are inclined to hold that the appeal be admitted and considered on the following substantial questions of law. Number 1. Whether the judgment and decree passed by the first appellate court it was against the dead person or
Dead person.
in favor of her
It's
first,
against the dead person.
against a dead person is legal and valid. Number 2, whether the trial court and the first appellate court were justified in including the property at Phoenix Bay, which the appellant claims to be his inherited property, comma, within the hodgepodge of partition in the suit as well as the appeal. These two questions should suffice.
Malak. A lower court may kindly be called from worship. I will prepare
Yes,
some
yes.
paper book worship. And then this appeal can be taken to the final disposal by the single judge.
The issue usual notices, lower court records be called for. Paragraph, the appellant is directed to prepare requisite number of paper books. Upon inspection of lower court
Yes, ma'am.
records, upon inspection of
By the
lower court
registrar.
records. Paragraph, the appeal be placed before the honorable single bench for consideration.
Notice the registry requested to issue a notice for inspection, because once the record comes, before the registry and before the concerned officer, I can inspect the record.
Before that, Lena, the registry is requested to issue notice upon learned counsel for the appellant for inspection of the records upon receipt of the lower court records.
I'm deeply aware.
Next.
Your Lordship, I'm for the petitioner.
Yes.
Your Lordship, issue is to checking the road accidents. My client has come before the Lordship as a good Samaritan for checking the accidents on the road, because Your Lordship, within 6 months, there were 10 fatal accidents, and all the 10 victims has expired. That's why my client has come before the Lordship for the rescue of the general public. But even after lapse of 3 weeks, the respondent 1 and 3 and 4 has not filed the AO. This non-filing of the AO manifests that the respondent is playing with the lives of the general public.
You've come up against violation of traffic rules and.
Your lordship, and my client has come before the lordship with the suggestion that some speed breakers and all the other remedies may be done so that the accident may lessen. But even
It's
after.
already innocuous, yes.
I have filed my affidavit in opposition. I am for the police authority appearing in this matter, my lord.
You could say police authority has filed, I will use the reply, but the rest respondent has not filed. So I paid for heavy cost.
Who is appearing for the other respondents?
Right now, no one is appearing for the other respondents.
So you'll say, this is the situation. No one is here before the lordship. It is the highest court of the state, and no response on behalf of the respondent.
You appear for the administration also.
Administration also, but my, in this matter, police has specifically came to us. I can appear for administration.
You're appearing for all the respondents.
But
Your lordship,
So
I
is your affidavit in opposition comprehensive enough?
not comprehensive enough. No, it has given the details why the accidents have been taking
Do you
place over
have
that place and all.
reply. Your lordship, I want to know who is Mr. He is in what capacity before the lordship?
My I'm proxy of Mr. Shatadru Chakravarti. I'm appearing.
So
as a
proxy has power to come.
My proxy has power. There are Supreme Court and Delhi High Court judgment when proxies are prepared.
So please show the judgment. Please show the judgment.
I'll show the.
I am not satisfied.
There is an affidavit in opposition on record.
Your
You
lordship.
come back within 7 days with an affidavit in reply.
Your lordship.
Yes.
And-
I think you can appear for all the, because there is no.
I can appear for all.
Yes.
I'm appearing for. Let me.
So your lordship, cost may be imposed.
For what?
Your lordship, even after 3 weeks, it is not a. Your lordship, matter is related to the public. I have not come before the lordship for asking anything, but for the, your lordship, for the welfare of the public.
When you
So
receive the opposition,
Today, Mother.
today only.
today you received.
So your lordship,
See the
they have
course of action.
your-
Let us see the course of action.
exemplary cost, exemplary cost,
Paragraph number 5, my lord.
so that they may come further with their preparation. Otherwise, they will become they
So
are.
due to the negligent activities of the people driving over that road and people are crossing without following the traffic
You
rules. And
have taken a decision for speed breakers, I find.
But that police have given a suggestion for speed breaker, but we have to consult with PBMC also. PBMC have to inspect whether installation of speed breaker over that road is possible or not, because it is before creating speed breaker over a road, it also has to be a certain how much with how much speed a car or vehicle is coming upon that road. Whether even the speed breakers also can sometimes cause the accident. But that has to be ascertained, my lord.
Your lordship, I have seen the speed breaks in the cities. There are many speed breaks. They are very helpful, but they are saying this. A speed break is.
And it's not like that installation of speed breaker will anyhow be going to prevent accident at all.
So for the last.
Accidents are negligence.
This, they are trying for this. There must be a speed breaker compulsory within 1 week, but they are trying, they are delaying tactics and playing the lives of the people. I condemn and highly condemn the lethargic situation of the respondents, and I humble submission that
Accidents cause all over the body.
maybe
That is causing all the over.
also on the respondents. Your lordship, it is too much.
Please come back with your reply. In the meantime, please take all necessary steps.
But I'll take necessary steps.
Affidavit in opposition filed on behalf of the respondents is taken on record.
Respondent number 2.
Filed by respondent number 2 is taken on record. Paragraph, the petitioner seeks to use an affidavit in reply to the affidavit. Stop. Affidavit in reply be filed within 7 days. Within 7 days from date. Paragraph, in the meantime, comma, it is expected that the respondent authorities shall take all necessary steps to ensure that there is no violation of the Motor Vehicles Act and rules by the vehicles at large. Stop. Stringent steps be taken by the authority in the event of such violation, comma, if any. Paragraph, let the
Lordship,
matter be placed before the
regarding
next
speed
available
breaker,
circuit bench. Yes.
regarding a speed breaker, regarding a speed breaker.
Stated all necessary steps, suggestions are there in the opposition.
And
Please go through it and come back.
your lordship, and within 1 week,
Yes,
they may take a initiation within 1 week.
you please come back within 1 week with your reply. It will be placed with the next.
I will come in the next circuit.
Next, yes.
That's apply, all yours.
Great.
These are continuous efforts.
Yours.
1 week, 2 weeks will not really matter. It has to be done continuously. Okay.
I'm extremely sorry, Your Lordship. This matter had to be mentioned before the single bench, and I have mentioned before the division bench. Let it be in the days list before Your Lordship, Your Lordship.
The matter be placed before the single bench.
Yes, yes, Lordship. Oblige, Your Lordship.
PRI-DB 9 of 2022. Data 4 of 2023 with diameter.
Your Lordship, if I may,
Yes,
I am for the appellant, Your Lordship. In Mat 4 of 2023, I have filed a leave to appeal, Your Lordship. There was a direction in the month of July for opposition and reply. I have filed my reply also, Your Lordship. In the meantime, Your Lordship, there was a stay granted in the other appeal, Your Lordship, which has expired, Your Lordship. Now, I will be directly affected, Your Lordship, if the stay is not extended, because I am the person who is operating there and running the marine culture. Now, Your Lordship, if I may be allowed to place the case, the facts of the case, Your Lordship.
give me a minute, give us a minute, please.
This has been served yesterday only in the evening and
What has been served yesterday?
But this reply which they have filed. and-
Reply has been served yesterday, Your Lordship, but the urgency is, Your Lordship. It is just a leave to appeal, Your Lordship. My submissions I had made previously on the last occasion. At least the stay be granted if the leave to appeal may be not be allowed today. If the stay can be revived and extended, because Puja vacations are coming up, Your Lordship.
Extended.
Yes, Your Lordship.
Yes, that was extended, Your Lordship, so far as I remember. Yes, I find an order in the previous circuit that has been extended.
It has been extended.
September 20.
After September 22, Your Lordship, my instructions are there was no extension. I am submitting on instructions. Your Lordship.
September 29.
October. September 29th is the last order.
Yes, it was extended. I think he is not aware of that thing.
Your Lordship, I was, I'm tender my apology, Your Lordship. I was instructed that the stay was not extended.
No, it has been extended. And I believe it's not in your favor also.
Yes, Your Lordship.
You're reaping the benefit of the order maybe, but it's not in your favor.
Yes, it is not in my favor because I am operating there. The license is actually in my favor. That is my submission before Your Lordship. The license was granted, the contract was with me, and I am operating over there.
You should have served the copy a little earlier, sir.
Yes, Your Lordship, that is, but if the stay is extended, then I have no problem. If it can be taken up in the next circuit bench, I have no problem.
The next circuit, Your Lordship.
Let it be further extended till the next circuit.
Your Lordship.
Yes, Your Lordship.
By consent, the adjournment, not this extension.
You have given it last time.
By consent of the parties. The matter be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till next available circuit bench is
16th November, Your Lordship. So let it be
20th
20th.
November.
Your Lordship.
Be
Yes,
extended
Your Lordship.
November, all and further orders, whichever is early.
Your Lordship. Oblige, Your Lordship.
My lord, may I beg to appear on the virtual mode, my lord?
Yes, yes.
Yes, well, I am for the petition, my lord.
And I am appearing on behalf of the administration led by Mr. Chakraborty. So, my lord, one thing can be done that he can make his submission tomorrow and this matter can be kept for tomorrow for Mr. Chakraborty's submission.
How many matters can be kept tomorrow for?
Because
Yes, my lord.
this matter is regarding regarding actually this actually they have been working as a doctor. He can place his case. They are working as a doctor. Subsequently on September, their contacts become over. Now they are relying upon a judgment passed in Andaman Sargent.
Let us hear the yes.
My lord, my lord,
Can we
my
deal
lord.
with this? Is it a short matter?
My lord, it is a very short matter, but a very urgent matter, my lord.
Yes, yes.
My lord,
please.
the petitioners, my lord, was appointed, my lord, in the year 2020 in the hospital attendant and the several posted and they are working. But as per notification published by the, my lord, ANIMS department, through, my lord, the recruitment process, they were appointed. But subsequently, thereafter, my lord, the time to time, their engagement was extended. My lord, kindly see, my lord, the first notification of the recruitment, page 19, my lord. Page 19 is the first notification. Advertisement made by the, my lord, the AINMs, my lord, the petitioner made application and thereafter selected. And engagement letter was issued in favor of the petitioners.
Yes.
So the first engagement is the page 20, my lord. My lord, got it?
Page 21? Yes.
Yes, 20. My lord, subsequently thereafter, my lord, time to time, my lord, on first, my lord, their engagement were extended for the 6 month and 3 month. My lord, 25th November 2022, my lord, page 46. Their engagement has been extended first time, no, page 46, my lord. And my lord, then thereafter, my lord, in 13th April 2021, page 42, my lord, the second extension was made. And thereafter, my lord, in 29th April 2022,
Page 41.
page, my lord, 48, my lord, the second extension.
Yes.
And thereafter, my lord, page 50 is the fourth, and subsequently last extension was made in page 52, my lord. Kindly see, come to my lord, page 52. For the, my lord, in the top, my lord, for the 6 month. So, my lord, their initial appointment, there is no condition for extension, but subsequently thereafter, their appointment by engagement time to time extended by the authority. But what happened, without any notice, the authorities are going to recruit another employee in the contractual basis by defying the petitioners. Your lordship knows very well, this is the strictly prohibited by removing the contractual appointment to appoint another contractual appointment. That is illegal because they have to make the recruitment post, fill up the post by way of the regular appointment. That is another issue. But there is a several judgment your lordship knows very well. This the contractual appointment. Initially, this appointment was the casual appointment, but after coming to the Umadevi judgment, the 2006-41 SCC knows very well, my lord, because this appointment, which appointment was the backdoor appointment without following the recruitment rules, they cannot be claimed for the regularization. But this appointment, by following the recruitment rules, subsequently thereafter, the long time, their appointment has been extended time to time. In this regard, for the protection of the employee, those are working, the different courts and also the Supreme Court are thinking that their appointment should be, my lord, their engagement should be protected. So judgment was divided, judgment was passed. So contextual appointment cannot be replaced by the another contextual appointment. But I have challenged, my lord, the notification based on impugn notification published by the department, page 54, my lord, kindly come to the page 54. ANIMMs, the authorities are going to fill up the post by giving the advertisement to the another contextual appointment by deprive the petitioners. Well, the similar circumstances, well, the one petition, same department was moved before the Honorable the Calcutta High Court. Well, this circuit bench also, well, kindly page 58, well, Justice Bosak was there. Well, they strictly prohibited them to giving the engaged by the new contextual appointment by deprive the those are working. Well, we are the similar footings, my lords. What happened? The contractual, if the after coming into the Umadevi judgment, the some candidates was appointment the casual laborer, they made application before the court for equal pay for equal work. But after coming the judgment to protection, to give protection up to 60 years, the different departments the frame a scheme. You cannot terminate with the casual worker up to the age of superannuation. There is so many other schemes. I'm not coming into that point, my lord. But Honorable High Court as well as the Supreme Court, the protected the casual worker. This is the on the basis of the principle that, my lord, the authority cannot deprive the contextual worker. Those are working in the long time and extended time to time. Replacing them by giving the another replacing the another contextual appointment. This is the strictly prohibited by the also decided by the difference laws. Your Lordship knows very well. So this order, I am placing this order earlier order is restricted. Is restrained the authorities not to fill up the post by depriving the petitioners. Well, I made several representation before the authorities. The page 64. Kindly page 64.
Yes.
My ventilating our grievance, those though you are working since 2022 to till September 2023, and for the for the thinking about the revenue, again and again recruitment process was not conducted by the authorities. So they have decided their service has been extended time to time. But we are made the representation page 64 by ventilating our grievance. What is our service would be continue not to fill up the post by the another contextual appointments who was not working in the department. So, I supporting my submission. I am placing the judgment. The petitioners possibly present here with the copy of the judgment. Kindly take the
Who is
copy.
appearing the petitioner here?
Yes,
Basically.
He is not the expert. I am praying apology for that. Difficulties appearing to the principal bench. Kindly accept. I am extremely sorry, my lord.
Yeah.
There is a judgment 2007-13 SCC.
Yes.
Page 292.
Yes.
This is the Harguru Pratap Singh versus State of Punjab. Kindly see page paragraph 3, my lord.
Yes.
This was the contextual appointment, my lord. We have carefully looked into the judgment of the High Court and the other pleadings that have been put forth before this court. It is clear that though the applicants may not be entitled to regular appointment as such, it cannot be said that they will not be entitled to the minimum pay scales, they should not be committed to regular income and appointment. The courts of adopted by the High Court is to be displaced on an ad hoc arrangement by another ad hoc arrangement, which is not at all appropriate of these persons. This proposition, the one ad hoc appointment cannot be replaced by the one ad hoc appointment. This is passed by this the Honorable Supreme Court in 2007-13 SCC page 292. Another the judgment of the Uttarakhand High Court. This is the kindly see the CWP 2693 of 2021.
Can you repeat the citation, please?
The citation is?
2000, this is the unreported, CWP 2693 of 2021.
Yes.
The second paragraph, we have heard, last portion,
Yes.
we have heard that the council of the parties and are of the opinion that petitioner is entitled to the grant of the interim relief.
The same proposition.
Yes, same propositions. And another judgment also, the unreported, the page, the WPSS number 1485 of 2015.
Yes.
This is the same proposition.
Yes.
And
Yes.
also, the one reported judgment at the Supreme Court 2018-11 Supreme Court cases, page 10. The paragraph 6, 15 and 17. Page 13, kindly see, come to page 13.
Yes.
The page 13, the petitioners, those who have engaged more than 35 years and who are contract basis for the 3 years, they also sought and direction of the corporation extend the benefit of the regular pay scales with consequent benefits and perks attached to the regular post of the Ayurvedics. And from the date of their initial appointment, however, when the writ petition come up for hearing, the respondent writ petitioner submit that they would be satisfied with the two directions or issued. The first being that those who had become overage should be given the benefit of the age relaxation. And second, they should not be replaced by the persons then other than the regular appointment. Their appointment should be extended because their appointment should be terminated by giving them the regular appointment. This is the proposition. And only my last judgment I am placing before your lordship. The 2019 4 SCC 118.
1992 for SCC. Volume
Yes,
4.
yes, yes. This is the same proposition. Those are working on contractual basis. They cannot be replaced by the another contractual appointment. The paragraph, the 41, 44, 46, 48, 49, and 55.
And that is 1992 4 SCC.
1992 4 SCC 100-118. So, this is the proposition, Yes, the as per the earlier order passed by this the honorable court, this is the respondent authorities cannot replace the appointment of the petitioner as because petitioners are not been appointed by the back door. They participate in the selection process, and after participating in the selection process, they selected, and thereafter they are appointed. And their service, in the initial engagement letter, there is no clause of the extension, but subsequently thereafter, the authority decided their service should be extension because they are not possible, the regular advertisement and recruitment process, due to revenue, to save the revenue, their service has been extended, they are without full satisfaction of the authorities, they continue 2020 to 2023. But the surprise, that is the authorities without considering the candidature, then considering the earlier the appointment and the engagement, they are going to the fresh the contractual appointment by deprive the petitioner. This is absolutely illegal. It should be kindly direct them my lord, to not to fill up the post without considering, my lord, the case of the petitioner, my lord. But this is a clear provision, my lord, the principle of the, my lord, the natural justice, my lord, their service cannot be terminated in such a way without issuing any notice. Their impugned order notification has been passed by, my lord, the yes, my lord.
Yes,
Whatever Mr. Chakraborty submit. My submission today is that first of all, they are not been terminated. Their contract come to an end with the effects of time. First of all, my lord, kindly see the annexure P2, which is page number 20, my lord. It is clearly mentioned duration of contract. They were taken as a COVID warrior. They are not DRM. They are not daily rated Mazdoor. So, my lord, at the time of COVID, emergency situation arises and they have been taken. My lord, will recall that we have shown that LG's suspension order in the Supreme Court and all those things. Thereafter, my lord, the decision has been taken by the administration.
that's the termination of a scheme.
Scheme plus, my lord, the decision has been taken that this kind of casual workers will not be allowed with non-sanctioned posts. Whatever have to be done, that has to be, because these are creating problems today.
But
So whatever has to be
vacancy
done,
is for a contractual post.
my lord, contractual post. But my lord, first of all, kindly see the nature of work. The judgment he is relying on, which is being the
Will you
Tandaman
consider
Sari
the
judgment.
representation?
Yes, my lord. That order can be.
Yes, let the authority consider your representation in the light of the judgments that you have referred to.
Yes, yes. But one thing is, my lord, not to fill up the post, all posts, till the decision has been come, my lord.
Instead of calling for affidavits and spending more time on the appeal, on the matter, let the authority, let it be sent back to the authority. Let them consider upon hearing you and all
Yes.
other concerned. And in the light of the judgments, let us
My
see
lord, kindly
Yes, my lord.
this page number 3 of this judgment for once, my lord. Kindly.
which judgment.
He is annexed in this his petition, my lord. Page 6.
Earlier judgment, the same recruitment process, my lord, this honorable court was pleased to pass, my lord.
He has referred TN supplies are referred, my lord, bottom last paragraph. Last paragraph at my lord, the para number 3. The relief sought by the writ petitioner were in respect of employees whose service were terminated. But there clearly there is a termination. Here there is no termination. And here they are clearly not appointed on the basis of contract.
My
Contract.
lord, subject to lordship correction, my lord, my learned friend is too clever because, my lord, they are not allowing to work, but they are saying not terminated.
That my lord, I am
They are
agree.
not allowing to work.
But
So what is the difference between the not allowed to work and termination, my lord?
Let the authority decide.
Yes, but in the meantime, I praying one thing, my lord, not to fill up the all posts. My lord, that should be recorded till the reason order has been passed, my lord.
that will be
Decided, sir.
But let that
Yes, yes.
just this could not be staged, my lord. This will going to create problem.
Disposal of the representation, sir, the notice will not be given effect to.
Yes, but that is what I'm praying before, Lord.
Contradictory, it becomes infractuous.
My lord.
Yes. The petitioners assail the vacancy notice issued by the Director ANIIMS on 11th July 2023, inviting application for the posts mentioned therein purely on contract basis for 1 year and co-terminus with regular recruitment. Paragraph. By virtue of a notification issued on the date of page 19,
My lord.
Or the
page 19's date, the notification.
No, no,
Page seven.
that notification of 2023.
Page 19
This,
notification.
yes, yes, this is the first notification, but on the bed, this notification petitioner or any case.
The date of the notification I am asking for.
Date of the notice, not,
Notification is a COVID-19's notification of
It's page 9.
that is not.
in Marathi. It's very illegible in my copy
I
Marathi.
do not find that.
Possibly interview date is 11th August 2020. The first line of the walk-in interview notice.
11th August
Will
2020
be conducted on.
and 12th.
Yes,
September.
Because this notification
11th August 2020 is the interview date.
by virtue of a, by virtue of a walk-in interview notice, walk-in interview notice issued by the authority, comma, the petitioners were appointed on contractual basis by the authority comma, their appointment being extended from time to time comma, the last extension being up to thirtieth September 2023.
Yes, yes.
Vacancy notice was issued by the authority for contractual appointment to the posts already held by the petitioners, and the service of the petitioners were not extended by the authority any further. Stop. Placing reliance upon a judgment, reliance upon an order passed by a coordinate bench of this court on December 10, 2021 in WPA 295 of 2021, as well as the authorities in, there are 4 authorities here, please record the names. In such and such, comma, learned counsel for the petitioners submits that the authority could not have advertised for appointment to contractual posts upon termination of the contractual service of the petitioners. Stop. The authority could at best have issued such notice for regular appointments. The petitioners seek quashing of the said notice. Paragraph. Per contra, comma, learned counsel for the respondents submits that the contractual appointment of the petitioners has come to an end with a flux of time. Stop. The said contract has not been extended by the authority any further. Stop. The authorities relied upon by the petitioners are not applicable in the present case insofar as their appointment is concerned, since they are no longer in service as on date. Paragraph. I have considered the submission, the rival contention of both the parties. Paragraph. It is not in dispute that the contractual appointment of the petitioners, which was extended from time to time, has ended upon a flux of time. Stop. The vacancy notice has been issued for the same posts, for contractual appointment to the same posts held by the petitioners. Stop. Paragraph. The authorities relied upon by the petitioners unanimously hold that one ad hoc arrangement cannot be replaced by another ad hoc arrangement, and an appointment on contractual basis cannot be terminated by a similar appointment on contractual basis. Stop. Such appointment should be for regular employees. Paragraph. The petitioners have submitted a representation ventilating their grievance before the authority on 28th August 2023. Which is yet to be considered. Stop. The petitioners seek a direction about the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits. Who should be the authority to consider?
Anims, madam. Anims.
Respondent number?
Respondent number
8.
Respondent number 8, madam.
8.
Eight.
That the 8th respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, comma, the petition is disposed of, directing the 8th respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 4 weeks. Within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, and in the light of the observation made by this court in the order, as well as the authorities relied upon by the petitioners, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Writ petition is accordingly disposed of.
My lord, in the meantime, my lord, not to fill up this portion, my lord.
Pending disposal of the representation, comma, the vacancy notice dated such and such shall not be given effect to by the authority.
Grateful, my lord, grateful. My lord, grateful.
Next. Here, I have filed the supplementary affidavit and extend the power of the law. Here I am saying for the demand.
Mr. Sivaland is appearing for the respondent authorities. madam. So short password may give not given.
The matter has already been heard.
Password.
Password.
Item 3, WPA 930, date of 2020.
3 is my application, my lord. The previous circuit, the matter had been heard, and this honorable court had taken a preliminary view, but the respondents were asked to file their affidavits 2 weeks, 1 week. Today
Is it
was,
being filed?
my lord, they have not filed an affidavit.
Change of brief, my lord. Today only I entered appearance.
Yes, there is a direction for affidavits.
That I am praying a 10 days time, madam.
10 days,
Thank
very well. Learned counsel for the respondents seeks 10 days accommodation as after S apostrophe, accommodation to use the affidavit in opposition as called for. Paragraph. Affidavit in opposition be filed within 10 days from date. Stop affidavit in reply, comma, if any, comma, be filed within 7 days. Within 7 days thereafter. Paragraph, the matter be placed before the next available circuit bench.
Item 4, WPA 941 of 2023.
My lord, my senior is appealing for the writ petition. Specific direction was given by this court to bring the RC record from Tahsildar.
Who is appearing for the respondents?
Sivmala is appearing in this matter also, my lord.
Yes.
So may be given.
How many matters can be passed over, sir?
I cannot. Not easy. Let it.
A very short issue. Passed over?
Yes, ma'am.
Item 5, WPA 974 of 2023. Find the errors and for the petitioner, my client intends to issue mandamus upon the respondents for disposing application P2, phase 10.
Who is appearing for the respondents? You are appearing?
Sivmala is appearing again. Well, I pass over maybe given, I just insist, my lord, what is the status?
Only direction.
It can be.
My client
disposed of.
seeks
Can
only
you dispose
direction.
of?
My lord, just pass over, my lord, because I am not a standing counsel on the court.
Where is the application to be disposed of?
Which one? Phase 10, you would see. P1. Application dated 20 September.
This is
22.
encroachment of revenue land.
No, my client has represented the petition to the respondents for disposing. He is not disposing for the last 1 year. That's why my client said, yeah. Only simple direction.
To dispose of
Disposal.
within 4 weeks. The petitioner seeks a direction upon the authority to consider the application filed by him before them on 20th September 2022. Stop. Paragraph. It is most unfortunate to note that an application filed by a citizen way back on 20th September 2022 has not been considered as yet. Paragraph. The writ petition is disposed of, directing the
Respondent number 2.
second respondent to consider and dispose of the application submitted by the petitioner dated such and such within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of those 4 lines.
Affidavit has not been filed. so
Allegate.
Allegations may be not.
Yes, that's the usual line that is recorded in all the lines.
But I have already received the brief in today morning, my lord. So I require time to go through it and take instructions.
He's asking for time.
will do the matter.
He's asking for time, sir. He has
Why not?
received the brief today itself. So some time is required for it.
Password.
On prayer of the respondents, the matter is adjourned. Paragraph, the matter be placed before the next available circuit bench.
Item 7, WPA 974 of 2021.
I am for the petitioner, very short matter, my lord.
Respondents,
Sivmala is appearing. my lord.
Can be disposed of. My review application is pending, the authorities are not deciding the issue. My lord, kindly come to page 8. I am the recorded tenant of the land. My lord, the government permitted me to extract page 10. Thereafter page 10. Government permitted to extract and transport Permission was given at page 10.
Yes,
Thereafter, my lord, kindly come to page 12. A fine was imposed upon me, 16 lakhs. No opportunity of hearing was given. Bottom,
illegal mining allegation.
yes. I filed, page 14, I filed a review application immediately. On 30th August 2021. The authorities are sitting tight over this matter, my lord. They are not disposing this review application.
4 weeks.
My lord.
Let it be disposed of. The petitioner claims to be the recorded tenant of the plot in question and submits that he was granted querying permit by the Assistant Commissioner within bracket settlement on October 9, 2020. Stop. By an order passed on 20th July 2021, the Deputy Commissioner, South Andaman District,
Without giving opportunity. of-
slapped a fine of rupees 16 lakhs upon the petitioner on the allegation of illegal mining, without granting an opportunity of hearing to the petitioner. Stop. The petitioner filed an application before the authority on 30th August 2021, seeking review of the penalty imposed upon him. Stop. The application is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the application at the earliest. Paragraph, learned counsel for the respondents submits. The Assistant Commissioner should consider.
No, Deputy Commissioner.
Deputy Commissioner.
The parent order was passed by
Submits
Deputy Commissioner.
that the first respondent be directed to consider the application in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the first respondent to consider and dispose of the application submitted, the review application submitted by the petitioner dated such and such within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of, Ms. Pollens.
Oblige, ma'am. Oblige.
My lord, views is appearing for the petition, and I'm paying the password.
Let it be first.
My lord, 8, 9, and 10.
Please call him, sir.
But
He will-
my lord,
he
in
can-
9 and 10, one submission is that 9 and 10, yesterday on the evening, we have received the brief. This is a very complicated matter. Your lordship will recall that one forest matter is there where seasonal, in previous cycle, single judge has given a stay order of stay upon the seasonal workers and their engagement, my lord. There is a similar type of, my lord, petition. So, my lord, I will pray that let this matter be fixed on Thursday, because that matter is also been fixed on.
Thursday, I'll not fix.
Or my lord, make it next cycle, sir, because I could not even get the instruction from the department. They are saying they are seasonal
Note it,
workers.
Pass on.
next circuit.
My lord, password, my lord, views will come and.
Let it, because he.
Let him come back. My prayers will be safe, my lord. Let him, sir.
8, 9, and 10 password.
Service upon the respondent is not affected.
Not affected?
So, no, just not today, in the course of the day, we will never decide.
No, not today, no, for any further. Since-
This can be disposed tomorrow.
No, not today, sir. Tomorrow there are a lot of matters.
Thank you, sir.
Tomorrow, Mr. Chakraborty will take away the whole day.
This matter can, it may not, but this matter can.
What is the matter about?
It's for a direction to be issued upon that sub-register for issuance of sale duty.
Are you appearing in this matter, Mr. David?
SUVRA sir usually appear for the sub registrar. Let it be not today, I system whether he will appear so that.
Very well, not today.
Yes. This is the NM Global's judgment that will apply in this matter. So that judgment has been, it's been reserved. The order has been reserved by the Honorable Supreme Court on this week.
So next, sir,
Next, sir.
on prayer of the respondents, the matter be placed before the next available circuit bench.
Item 13, RSA 1 of 2019 access to.
For the appellants, it's a required time, you lordship.
So next circuit,
Next, sir.
on prayer of the appellant, the matter be placed before the next available circuit bench. It's an appeal, it will take time, isn't it?
Yes, it will take time. Second.
Give your name. Next,
Item 15, WPA 59 of 20. We should be paying for the petition, I'm paying for not today.
not today will not be possible in all the cases, sir. Let it appear before the next circuit.
My lord.
On prayer of the petitioner, the matter be placed before the next available circuit bench. No use encumbering the list unnecessarily, isn't it?
Item 16, WPA 94 of 2020.
16 to 19 can go to next circuit.
No, my lord. Password, my lord.
No, I am not prepared. No, 16 to 19, I am not
His
prepared.
prayer.
On my
prayer of
prayer,
the-
let it go.
Password.
On his prayer, sir, you are not responsible. Don't worry.
We can do that.
My lord.
Please speak to Mr. Kumar so that he is not held responsible.
I've told Mr. Kumar. Morning only I have told Mr. Kumar.
That's fine.
Yes, he is there. You are saved, sir.
So 16 to 19, I am praying for party, not this session, because I am not prepared.
Mr. Kumar, your junior is very scared of you.
My lord.
16 to 19, he is asking for next
Hello.
circuit. On prayer of the respondents, the matter be placed before the next available circuit.
Item 20, WPA 84 of 2020.
My lord, I am appearing, my lord.
Respondents? Mr. Shiva Balan, where is he? Yes, where is he? Passed over.
My lord, may I mention, my lord, item number 6, I was not there. It's a very urgent matter, my lord, item number 6 and 8, my lord. And it can be
Pastor.
disposed of. I don't know, my lord, in my absence, what
No, I have just stated that today morning I have
Passed
just
over.
got the bit.
passed over, my lord, 6 and 8.
I'll call the pastor. over.
6 minutes, 1
Six, I
to
feel-
next circuit.
No, my lord, it's a very urgent matter.
He is not ready.
No, my lord, he is not required to be ready. What happened, my lord? I was admitted, these students were admitted in MBBS college. As per the NMC regulation, my lord, after 4 attempts, they are not allowed to take attempt in one year, first year. My lord, they failed in all the some of the subject despite of 4 attempts, which is permissible under the law. Now, my lord, the college has thrown them out from the college. Now, they are not on that. My lord, the difficulty is that the college retain all the original documents of these students, which is not permissible under the law. I will place 4 judgment. My lord, what I am on, my lord, let them consider it in the light of these 4 judgments.
So let 6 be not today.
My lord,
Please come back with instructions.
my lord,
My lord.
this is what I am seeking, my lord.
My, I am also saying not today.
Mr.
I am not so that.
No, that's what next.
6 should be not today.
That's our man is
Six
gonna
should be
take
not.
care of them. I have not paid for next circuit.
And 8, my lord, it can be disposed of, my lord.
Shall I call the pastor over matters?
My lord,
Because 8, my lord, it's a very peculiar case, my lord.
He run through the list. I'll call the
My
pastor.
lord, my lord, my lord.
21.
Item 21, WPA 44 of 2021.
I am for the petition in this case. It is a ready matter.
Ready, ma'am? Respondents,
Respondent, Mr. Sabru is appearing, he will be coming tomorrow.
my lord.
can we take up tomorrow?
Yes.
But this, I think this matter will going to
If
take
possible.
time because there are what happens is two of the employees are fighting amongst themselves for the promotion basis.
It's not the case. It's
And
not
there are,
the case.
if I recall correct, I might be
Make
corrected.
the submission. It's not the case.
Appear before the next available circuit. It will take time. because affidavits are there, it will take some time. The matter requires extensive hearing. The matter be placed before the next available settlement.
Item 22, WPA 59 of 2023.
My lord, I am appearing for the petitioner. This is that matter. Yesterday also I was pursuing.
My
my lord.
22, I am praying for not today or
My lord, not today, my lord, because this is that matter, my lord, where they have not referred the matter before the labor court. There were two cases. One they have referred, other they are saying you are a contract employee, it cannot be referred. Same work.
Let
my
it be
lord.
not today,
My
if
lord.
it's possible tomorrow. Let
my
it be.
lord, my lord.
My lord.
Item 23, WPA 485 of
My lord, I am appearing in this case till date, they have not filed affidavit in opposition despite
Asking for last extension.
last extension already there.
Peremptory, my lord, peremptory
Fine.
extension, one week.
Last
peremptory.
peremptory,
long
you have
back,
to add words
long
to the
back it was.
dictionary now. It will not be sufficient. Learned counsel for the respondents seeks further extension of time to use the affidavit in opposition as sought. Paragraph, as a last chance, the prayer is allowed. Paragraph, affidavit in opposition be filed within 1 week.
1 week, my lord.
Within 1 week from date. Paragraph, affidavit in reply, comma, if any comma, be filed within a week thereafter.
My lord. My lord.
Paragraph, the matter be placed before the next available circuit bench.
Item 24,
Your Lordship, I am for the petitioner. This is that case, Your Lordship, where the authorities have raised certain allegation upon the petitioner and asked him not to enter into the airport, whereas police verification, everything is in my favor. But
Yes, respondents.
this is Tulsilal is appearing a lot. He has just left the court, that is the funeral of his relative.
5
So
months
he has just
more
not
than,
today, he has prayed, Lord, he has come in the morning in the court.
so let it be, Your Lordship, top in the
He has said
tomorrow's list, Your
A
Lordship.
supplementary affidavit in opposition was called for. Where is
it
it?
has been filed, it seems. Lord. He had told that.
The supplement, have you received a copy?
Your Lordship, I have filed my opposition. Your Lordship.
Supplementary affidavit.
Yes, yes, let it be considered, Your Lordship. I have no issues.
He wanted to file it on the last occasion.
He
No,
said,
he
it
has told that he has been filed.
has been filed.
Just not today, Lord. Because
Very well, not today.
Your Lordship.
Item 25, WPA 625 of 2023.
My lord, I am appearing for the petitioner, my lord. It's a ready matter.
Yes,
It's we have filed our affidavit in opposition, replies also been filed, but my lord. Let it be, my lord, fixed on short matter.
Thursday.
No, no, my lord, let it be in the next. It's a long, it will take some time. There were several judgment of CAT, High Court,
Next circuit.
my lord.
By consent of the parties,
Okay.
the matter be placed before the next available circuit bench.
ये तो मेरे को अब कहिए अब करना तो कीजिए तो मेरा है मेरा हाँ फाइल
26, WPA 643 of 2023, WPA 320.
My lord, I am for the petitioner, my lord.
Yes.
My lord, is making construction, my lord, demolition order is already there. Then there should be a stay, my lord. Page 18 may be seen, my lord.
If demolition notice is already there, then why aren't they demolishing it?
They are not demolishing.
Who is appearing for the
My lord,
authority?
not only that, my lord,
Administration?
not only that, my lord, the second one connected case. Tactfully, my lord, without making me as party, approach this honorable court on the garb of want to repair the building. To obtain one order.
Is there any stay of the notice? Like in any of the cases?
No, my lord.
Yes, Mr. Shivbalan, you are appearing in this matter?
Yes.
Why hasn't the demolition work been done? There is no stay.
There was a stay,
The
No,
private
why is
respondent
this-
chooses not to contest. Learned counsel is not there. So, but there is no stay. Why isn't the work being carried out?
In the second, my lord, can application I filed in the second one, that may be seen, my lord. Can one. Can one, my lord, page 7.
No, that's that he cannot consider it on merits because the learned counsel is not there. But then,
Is making construction, my lord.
Copy of the can has not been served to you.
Is making construction even after demolition order. Page 18 is the demolition order.
Page 18 is not the demolition order.
Yes, madam.
R1.
Page, P3, madam.
This is R1.
No. WP 643 may be seen,
Oh. 643 is
page 18.
page 18.
18, madam.
Yes, P3.
Demolition order is there, he's making, merely is making construction. Enclosed photographs also. So joint,
Permission was granted to.
permission was granted for repair. That is the reason I want to show the can application in another matter. Can one may be seen? I am not, I was not made as a party. Behind my back, approach this court, obtain the order.
So let it be placed before the next circuit. Let there be an observation that any construction made in the land in question will abide by the result of the writ
Already
petition.
there is a demolition order. There may be a restrained order. Otherwise, he will complete the construction.
Permission was given for.
Permission granted by whom? Demolition order is there.
There is a demolition order. How can you pass contrary orders?
No, we have not passed. The Honorable Court has granted permission for
Repairing.
Court has passed.
Under the garb of repairing, he is making new construction.
It's the disputed fact.
Wow, what disputed
This is
fact.
the second matter.
Second matter, my lord, my can application, page 7 may be seen, the order, repairing order. It was categorically mentioned that no new construction should be made. He is making new construction.
It's a contested matter, my lord.
Yes,
That
page
is-
8, last paragraph may be
Any
seen.
construction made in the
Yes.
meantime shall abide by the result of the writ petition.
My lord, we will complete the
And there is a
construction.
demolition order also, sir. There is no stay. So why aren't you complying with it?
Number of litigation pending and they have.
Is there a stay of the demolition order?
No,
Yes, ma'am.
If there is no stay, how can you stop demolition work? Let there be 1,000 litigations. There is no stay.
no stay.
So that is the intention of the court.
Exactly, my lord, I'm not-
If the court wanted to stay, the court would have stayed. The court has not done that.
He is making
Please take
further
this into
construction,
account.
my lord. That is the whole difficulty.
Concession is being given by the authority.
It's a joint property. He is making further construction in the disputed property.
On prayer of the private respondents in WPA 643 of 2023, the matter is adjourned. Paragraph. Learned counsel for the, in the first matter, you are the petitioner.
Petitioner.
Learned counsel for the petitioner in this matter submits that despite an order of demolition passed by the Secretary, Municipal Council on 5th January 2023, the private respondent is continuing to raise construction in the plot in question illegally. Stop. Paragraph. This court records that despite order of demolition being passed on 5th January 2023, the said order has not been implemented by the authority till date for reasons best known to them. Paragraph. The matter be placed before the next available circuit bench. Paragraph. Any construction
He will complete
made by any of the parties in the plot in question during pendency of the writ petitions shall abide by the result of the writ
My lord,
petitions.
already there is a demolition order. He is making further construction.
It will
That
be
may be
demolished,
stayed.
sir, it'll abide, what will be stayed?
Further, you should not make any further construction.
You have heard what I've dictated. It will abide by the result. It will be demolished. Next.
Obliged, my lord. Total 28 WP 691 of 2023, 690, 668 of 2023.
Lord, I am appearing for the private respondent.
Have gone through the report, my lord. The Port Blair Municipal Council.
But copy of the report was not served upon me.
You are appearing for the
Private
private,
respondent.
you are the petitioner.
In one matter, I am the petitioner, my lord. There is two matters.
In one matter, I am the petitioner, madam.
The first matter,
Second one, madam.
First one.
First one, sorry, madam.
In second one, I am the petitioner.
oh, in the first matter, Mr. Kumar is the petitioner.
My lord.
The site inspection report was submitted on the earlier date.
They have
Code for the
stated that
police to
at
file
present
the
the work
report.
is not going on,
The
but
private
the
person
stay order was
and-
passed on first of March 2023. And they were constructing, unauthorized construction was going on.
At site, and
subsequently,
however, the
no.
council has issued a stay order.
On 24,
Construction
2023,
notice wherein
and the
such-
provisional demolition order also
Addition
passed
to the
on
party
4th of
responsible
August
for the-
2023.
Return to the-
That means the work was going on, madam. It was going on. That's why this stay order has been passed. Now the provisional demolition order also been passed.
My lord, it requires an hearing, since my learned friend was pressing for interim order. That's why I thought it, but after going through the report, there is a
I
clear
don't
report.
think interim order is
Yes.
necessary at the moment.
No, that's why.
And he's going, there is difference between water and. So right now is no one.
No work is going. So, it requires a hearing, my lord, let the matter.
I think affidavits were called for that.
Affidavits are completed, my lord. I have.
In my, this one, the affidavit in opposition has not been filed.
Yes, not in all the,
I
not
filed.
in both the
In the,
cases.
no,
I filed, I have served you the copy. I have served, I filed affidavit in opposition in my.
no, my
learned-
lord.
Yeah,
Reply dear.
opposition did here.
In their first read, my
Opposition
lord,
by the private respondent.
My lord,
Yes, I have filed, my lord. I have filed. It is there. I'm to be here.
can the dear. Affidavit in reply I have received, my lord, with regard to my writ petition. In the second writ petition, the affidavit in opposition also,
Opposition is there in the second petition.
my lord, I have filed it. No, my lord, I have not received, my lord. I have not received.
So you are the petitioner in the second matter.
Second writ,
You'll use a reply to this?
my lord.
In the first matter, affidavits are complete, I think.
My lord, I filed the,
The,
but the department has not filed. my lord.
in the second matter.
In the first matter, in the first matter, the private respondent has filed the affidavit in opposition.
Official department has
Not filed.
सही बोली हम तुम कुछ दिया नहीं और मेरे पास कॉपी नहीं एक ही कॉपी है
Who is appearing?
I appear for the.
नहीं नहीं तुम झूठ बोल रहे हो गलती हो गया तीन
You have not filed, is it?
Not filed. The second matter.
नहीं है ठीक है हम तेरे से
Respondent numbers
Coffee
1,
bill
2
for-
and 3 in WPA 691 of
ठीक है, बना लेगा।
2023 seeks extension of time to use the affidavit in opposition as sought. Paragraph. The petitioner in WPA 668 of 2023 seeks to use an affidavit in reply. Stop. The matter be placed before the next available circuit bench. Please exchange your affidavits in the meantime,
My lord.
so that it can be heard by the next circuit.
All right.
Item 30 WPS 694 of 2023.
And for the petitioner, I
Yes.
am ready. my lord.
And for the
Privilege
number one.
granted by the court. While opposition may kindly be extended.
As
You
a
are appealing
last
for the
chance, as a last chance, my lord,
I have
already.
to pray. madam.
One and two are the official respondents.
They filed, my lord.
They have filed.
My lord.
Learned counsel for the private respondent seeks extension of time to use the affidavit in opposition as sought. Paragraph 1 week. Mr. Japan, affidavit opposition be filed within 1 week from date. Stop. Yes, 2 weeks.
Normally it will go to next circuit.
Normally it will go next. 2 weeks from date.
My lord,
Stop affidavit and reply, comma, if any comma, be filed within a week
as
thereafter.
a last chance. my lord. Otherwise they will.
Last chance.
No, that is there. You are not filing.
Learned counsel will be happy with that. Before that, seeks accommodation, after that, seeks extension, after that, as a last chance, prayer is allowed.
Oblige.
The matter be placed for the next available circuit.
Oblige.
Item 31 WPS 698.
I appear for the respondent authority.
Petitioner,
My lord, I am appearing for the petitioner. My senior is going to Chennai for medical purpose.
On prayer of the petitioner, the matter be placed before the make it like this, learned counsel for the petitioner is not available due to his medical checkup. Paragraph, the matter be placed before the next available supplement.
Item 32, WP at 7/27 of 2023. My lord, I am appealing to the petition. My lord,
I am for the respondent.
my writ application only for consideration of my representation. Fact is that, my lord, the Andaman and Nicobar administration decided to grant some compensation amount in lieu of my submerged land. They
In
sanctioned
lieu of
submerged land
submerged land, yes.
due to tsunami. The said allotted
Yes,
land was
yes.
submerged. And the respondent authority sanctioned the said amount, but till date, they have not released the said compensation amount in favor of the petition. That's why I came before this honorable.
Or my affidavits are on record, my lord.
Where is your, consider his application and
No,
pay
my
the
lord, it has
amount.
been considered, he has been paid certain amount, but there are two surveys there in his land. Primarily after 2004 and thereafter again on his request in 2012 or 12, my lord. Now, my lord, on the previous survey, certain 4.15 or certain hectares of land found in his favor, and in lieu of that, money has been disbursed to him. This money came from Union of India, my lord, from the ministry, my lord. At that time, a package was given by the due to tsunami by the Rajiv Gandhi Yojana. Certain package was that all are annexed over here. But in 2012, we have found that there are some more lands of is there. So, my lord, he has surrendered those lands as well. So, my lord, we have requested the government. There were at that time two schemes: either you take the land, either you give the land back, or you and take the money.
Compensation.
So he had given the land back and asked for compensation. And at that point of time, the funds were
Exhausted.
Exhausted, mother. So, mother, we have requested the ministry. We have given in 2023 also. We have given ministry the letters and all. Madam, see, mother, in my paragraph. Paragraph 13 onwards, mother. See. Meanwhile, DCN with a letter number such and such dated 28/1/2020 reported that the area proposed for payment of compensation in lieu of submerged is 1.81.25 hectares. The same was retreated by DC with a letter number such and such. Compensation sanctioned in respect of 2.3375 hectares of the land. Subsequently, the remaining area of submerged such and such was also surrendered by the joint co-tenants for compensation, which was accepted with a letter dated 4/8/2021. So remaining land they surrendered 2021 in RC number such and such at prevailing rate of rupees 9.39 lakhs. It is pertinent to mention that the area projected for payment of compensation before MHA was 1.092 hectares, which needs to be modified as 1.8125 hectares as per latest report received from DC North. As mentioned in the above paragraph, accordingly, the revised requisition needs to be placed before the ministry for release of additional funds. However, the MHA letter dated such and such has requested to submit a brief on and to initiate the present status of all the court cases, litigation, IS such and such, IS such, and any other litigation involved with respect to terms of reference mentioned in the recommendations of Shri Vivek Rai Committee. Annexure 1. Accordingly, reply has been furnished to the Deputy Secretary to the Government of India MHA with an administration letter dated such and such. Now, further, Under Secretary to the Government MHA New Delhi with a letter dated such and such, and Section Officer ANL Section UT Division MHA with an email dated 14/12/2022 also seek information on the same subject. The reply to above were also furnished to both officials with the Andaman letters dated such and subsequently the ASO ANL Section UT Division MHA New Delhi with an email dated 3/1/2020 they requested to furnish the updated status on recommendation of land matters pertaining to NN Iceland
As per the report of the committee of Shri Vivek Rai, former Chief Secretary, as the matter was with the Ministry of Home Affairs, the required inputs were furnished with a letter dated such and such. The Under Secretary GY letter, with a letter dated 15/3/2023 has sought further clarification in matter annexed P, which has been forwarded to DC South Andaman with a letter dated 23/2023. Another reminder in matter was also forwarded to DC with a letter.
So you are awaiting funds, placement of funds.
My lord, my lord. Reply from OCBC South Andaman still awaited. And we are also waiting for the funds, madam.
So the first respondent is responsible? The Union of India? Let there be direction.
Served upon Union of India, that is also a question.
We
It
have
is served. Where is the service? Because a direction needs to be given to the Union of India. Funds will be paid. Where is your affidavit of service? It's not there. Not served.
let it be fixed tomorrow, Lordship. I will file the affidavit service.
Have you served the Union of
I have
India?
served, but due to some mistaken affidavit service not been filed.
Not today.
This is that case, Your Lordship, where the MSCP benefit was not granted to the petitioner despite the fact that on the date when he became eligible, there was no case at all, neither departmental proceedings nor any kind of case.
Can it be fixed tomorrow, because information came to me that there is a Supreme Court decision also in regard to this employee, madam. So there is a
No,
Supreme Court decision
there's no
to
connection.
give in a separate.
I know about that case because I dealt with that matter. It's
Because in that
relating to
matter, I'm
promotion,
not-
a very different thing. It got nothing to do with this case.
MSCP madam is a promotion.
No, sir, MSCP is not a promotion.
Where is your affidavit in opposition?
My file, madam.
Reply, everything is ready.
Everything is over?
Yes. Everything. Ready matter, very short point is there.
Let it be not today, let us see
Your Lordship.
if we can deal with it.
Because I have to check that whether what.
That I am sure about. I am sure about that particular thing because I appeared before the day up to a division
Let it
bench.
come.
Yes.
Item 34 WP 848 of 2023.
Lord, I am appearing for the petitioner.
Yes.
Lord, I tried to locate the council who is been local council for appearing the respondent. He is not in station. But Lord, my submission is that the no stay has been granted with this on.
Oh, okay. This is the copy. It's not visible in the office.
Lord, my respectful submission is that not as no stay has been granted, the authorities who being the deputy commissioner who is the recovery authority, let him proceed, my lord, in accordance with the law. If what are
There's no
the,
bar.
but he is not doing it, my lord. He said writ petition is pending, so I will not touch with that. So that's why, my lord, I
You use the
mentioned,
reply.
I filed my opposition, my lord, because I am for the respondent
You are for the respondent.
who is under the Gratuity Act. I have been awarded with certain amounts. And as per the section 7 of
Who is
the
appearing for the bank?
Alakis Sarkar was the local council, but I have served the
Petitioner?
copy. So I have served
Next
the copy.
circuit, because yesterday also she didn't appear. I had to keep it.
As
today.
Malad has directed me to inform the other side.
You did not find anyone.
I find.
None appears for the petitioner. No accommodation is sought. Paragraph, the matter be placed before the next available circuit bench.
Not like that one line we added, it will not preclude the authority to proceed.
That is the law, even without me adding a line.
Blair.
Petitioner itself is not there.
Yes.
You can impress upon the authority because there is no stay order.
Blair.
Item 2 WPA 954 of 2023.
I'm for the private respondent, Lordship.
I'm for the
My lord,
official respondent.
here, my lord, the demarcation can be done in presence of petitioner as well as the private respondent. That can be done, my lord, giving a opportunity of hearing, giving a proper notice to the both the parties. And the after demarcation, the report has to be given to the parties, my lord.
Before that, I want to show certain documents. Kindly come to page 62, Lordship. No, starting from, kindly come to first page 60.
Yes,
Now, this is an allegation that they have not participated in the demarcation, the last demarcation. That was a dichotomy last time which could not be cleared. So, Lordship, in page 60, this is a demarcation notice. This is the demarcation notice of the last demarcation. Now, this says that whereas a complaint objection letter has been received from Shri Baby Mandal. Baby Mandal is a private respondent here. So, this notice was issued on the initiative of Baby Mandal. And in this, the notice was also served to Pushpavali. 6, if what you would see, 6.
yes,
So in this case, the notice of last demarcation was given to the writ petitioner hearing.
yes,
Now kindly come to page 61, Lordship. Now they have on the last occasion, they said that they have asked information by RTI which could not be provided to them. This is the application format which they have asked. Lordship would kindly come to point 2. Kindly arrange to provide me also the certified copy of the survey report of the demarcation conducted on 25/5/23 upon the land bearing survey number 399/3 and 399/4. These two land belongs to the writ petitioner, Lordship. And I have already shown to this honorable court that demarcation notice was issued for the demarcation of the land of the private respondent. And in this requisition of the information, they have given the date 25/5. Of this day, no demarcation has taken place. Rather, the demarcation has taken place on 28th, Lordship, of the same month, 28. Now, I'll show that thing, Lordship. Kindly come to page 62, Lordship.
yes.
This is a vacation notice by which the stay has been vacated. Kindly come to Lordship.
So where is the notice of 28th?
Yes.
Demarcation was made on 28th.
Yes. The notice of the demarcation is in page 60, Lordship, of 28.
That says that demarcation will be on 25th,
No, on 28.
25th, my lord.
25th.
Yes. Now
60,
that one is the demarcated revenue official. Yes.
So 25th, there was no demarcation.
There is no demarcation. It was in 28,
So where is the notice of 28th?
and they have participated in that.
Where is that document?
But that can be very well called from the official Your Honor.
It was called for actually.
Because in compliance report, she has put the signature. So presently the position is the Lordship, all the demarcation have taken place and they have participated in all. So they have come forward before this honorable court asking for a
Demarcation.
for a maintenance, for demarcation. But in this case, the demarcation is already done. Already done.
I would like to see the documents.
Yes, Lordship, that can be called from the record
The
of.
petitioner was present during the demarcation. Yes.
Yes, she was present. She has put the signature in the compliance report, as per my information.
My lord, I will bring the document on the right side.
You have not?
Page
No,
60,
There was
68.
direction
is
to
there.
file supplementary affidavit by the.
Yes, my lord.
Lordship, one more thing,
Yes,
page
yes,
68, Lordship, for us, for a while, page 68. This is the information which they have asked. Now, as per their government, they have asked the information which could not be provided. But they have asked the information of land of the writ petitioner. But on 28th, the demarcation has taken place on my land, or the land of the private respondent. That's why the authorities have said no demarcation has taken place on 25th of your land. So that's why they have not given any information, because what they have asked was wrong. They have asked the demarcation.
Committee needs to come with a report at least,
Lordship,
right?
Lordship. That will make very clear.
Because what does the supplementary affidavit say?
Lord,
This is the power of attorney.
The
This is only
power of
power of
attorney. But I was not
I
annexed.
received the copy, Lordship. I received the copy.
Will you come back with a report?
My lord,
My lord, if the fresh demarcation been done. In
If you have received the notice
Yes.
and have chosen not to appear, there is no question of a fresh demarcation.
But I have given adjournment on twice, my lord, 2 occasions. That is at page 37 and 44. I have given with the notice, but my health was not good, my lord. I was ill. I am 73 years old woman, my lord.
Lordship, these are fact. If they have participated, then there is no question for all this, Lordship.
But the report has not given.
As-
So that's why
Yes.
we're calling for a report. Official
In compliance
response.
with-
Because they are the best person to say whether you are present, because learned counsel says that you put your signature in the report. But
Lordship.
the report has not supplied, my lord. Please come back
That
with
has
a
to be
report.
given, my lord.
My lord.
If I was present, my lord. That report has to be given.
The report was, they have asked us in.
Counsel for the petitioner alleges that demarcation of the plots in question was held in absence of the petitioners. Paragraph per contra, comma, learned counsel for the private respondent submits that the petitioners were present at the spot during demarcation and put their signatures in the report prepared by the authority. Paragraph, learned counsel appearing for the official respondents seeks to submit a report in this regard. Paragraph, the matter be placed before the next available circuit bench. Okay.
Grateful, Lordship.
Congratulations.
Item 4, 491. As for the petition. Not my argument would be different. They were direct.
Who is appearing?
I appear for the respondent.
Showing that on the date when the impugned order was passed, I was present. They say that I was present. To ascertain this fact, the records were called for. Look, if the court holds, because even this was argued by the other side that the order is unappealable under the local regulation. Not before the.
You're on natural justice.
Yes.
Yes.
My lord. We have brought the record, my lord. They have represented and they have filed their written application for vacation of stay also. It
Needs
shows
to be
that-
filed, sir.
My lord,
Needs to come before the court on record.
my lord,
That's the issue in the writ petition.
my lord. We have brought the record, my lord.
Yes, the order passed on 8th September
lord.
2023.
Yes, ma'am.
Please show me. The hearing was on 7th September,
And yes, my lord. And order was passed on 8th.
8th September.
Yes.
You are Manorama Baru.
I am the.
You are M.A. Mohan.
MM. Manama Barua is the private school.
One Mr. M.M. Rajat was present on behalf of M.M. Mohan.
He happens to be my son. He's my son. He's my son.
He was present
He
during
was.
the hearing.
He's my son.
So it was in your presence. You were heard.
No, just one thing. In the morning hour, my elder brother has shown the record to me. He was so generous. Do not kindly compare this page, pen ink, with the second one. Malord would see, but same order. No, the one Malord left hand side. Left hand side ink, Malord may kindly be seen. The second page was replaced because in the second page, the signature of my son appears. Now, kindly see this one part. No, red coat cannot go into this matter. But the thing is, order was passed by the Tahsildar. I will approach the revenue appellate forum under regulation 28. Now, 35 of the regulation, I made an application before the Tahsildar. Till I go to the appellate court under regulation 35, the same Tahsildar can stay the order. Because this is something like, I'm not.
Have you made an application? to
Yes,
the
at page 24. At page 24, 35 application. Now, it is something like order 21, rule 5 application. The court which passes a decree can grant a stay. When I approach the appellate court can also grant a decree. So long I do not take out the appeal, the same court can grant. Or 35 is 90%. at page 8. I would approach before the appellate forum, but till such time, Your Lordship, I'm well within the time till now. Revenue officer, Tahsildar is one of the revenue officers in the hierarchy in terms of section 3. A revenue officer who passed an order or his successor in office may at any time before expiry of period prescribed for appeal or revision direct execution of such order to be stayed for such time as may be requisite for filing an appeal or revision and obtain a stay order from the appellate or revision authority. So the order is dated 8 September 2023. In terms of regulation 28 and 30, 45 days.
You appear to be an encroacher upon someone else's land.
My property is adjacent to these properties. Not kindly, it's my case. I'll show the land record.
A survey has been done.
My property, I'll just show it, land record. My wife's property, Indra Devi, I'll just show not kindly terms to page 6. It's not that I'm an encroacher of the third party. No, there is a boundary dispute, Lordship. Lordship, they said that I've encroached the private land. I'll go to the revenue appellate forum. 16 may kindly be seen. Indra Devi is my wife. I'm not kindly see.
Let this application be decided by the authority within 2 weeks.
My lord.
The 35 application, regulation
lord.
35, yes.
Well,
And I'll grant you liberty.
but till such time, because if they execute it, in 2 weeks, Lordship, if they execute it,
Can it be done within 1 week? The stay application.
2 weeks. Is the,
But please ensure that the execution is not done before that.
my lord.
Yes,
My lord.
from the bar, please ensure.
makes it in the
Cannot,
form of
cannot.
not.
This court cannot stay. Third learned counsels for the parties. Third learned counsel for the respondents produces the order sheets of RC number 1621 of 2022, which demonstrate that the petitioner's son was present before the authority and made his submissions when the matter was heard on 7th September 2023. The order impugned was passed on 8th September 2023. The paragraph, the order impugned is the said fact is not denied or disputed by the petitioner. Paragraph, the order impugned is amenable to appeal under regulation 28 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1966. The petitioner seeks liberty to refer an appeal against the said order in terms of the said regulation. Paragraph, the petitioner has filed an application under regulation 35 before the
Tahsildar, who has passed the order
Tahsildar
at page 24.
being the third respondent herein, and seeks a direction upon the said respondent to consider the application at the earliest. Paragraph, upon consideration of submission made on behalf of the parties, the writ petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioner under section 35 of the under regulation 35 on 14th September. You filed the application
14th of September.
on 14th September 2023, within 2 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, in accordance with law. Paragraph, the petitioner is at liberty to prefer an appeal against the order impugned dated 8th September 2023 in accordance with regulation 28. Paragraph, there shall however be no arrest to costs since no affidavits are certified.
Blair.
Any of my lord.
Yes, you can return it, please.
Oblige, madam. WPA 977 of 2023.
My lord, I am appearing for the petitioner, my lord. Here, this petitioner association is looking after the welfare and cause of suffering of stray animals, my lord. My lord, under the dint of an order passed by the CGM, two separate orders, my lord. 21 cattle were handed over to me to look after their affairs during the pendency of the case. Now, my lord, I am looking after their affair. I am an association which is not aided by the government. Now, my lord, in terms of, I am just placing one letter, my lord. I am sorry, it is not so legible, my lord. Page 28. If my lord comes to page 28,
Yes.
it says Animal Welfare Board of India, Ministry of Environment, Forest, and so and so. This is 3rd May 2018, my lord. It
Yes.
addressed to all the chief secretaries of the state and UTs. It says the Animal Welfare Board of India is a statutory body established under Section 4 of the Prevention of Cruelty to Animal Act 1960. The function of the board include the promotion of animal welfare, generally for the purpose of protecting animal from being subjected to unnecessary pain or suffering in particular. The central government has notified prevention of cruelty to animal so-and-so rule for the maintenance of animal seized in violation of act and rules made there under. It is noticed that the above rule are not implemented in letter and spirit in order to resort in avoidable circumstances the animal welfare organization and government agency. We therefore draw your attention towards the provision of Section 4 of cost of, date and keeping of animal during the pending litigation, my lord.
Is not legible.
Not legible. My lord, pending, it is pending litigation. Now, my lord, kindly turn to next page, my lord. I am just placing page 29. If my lord sees, there is a rate chart, my lord. Rate chart, my lord. The third one is 200 per day per animal. Got it, my lord? At the right hand side. It says daily maintenance and care for large animal. Now, my lord, these cattle are large animal. Now, my lord, for them, for maintaining them, 200 rupees is required per day for per animal, my lord. Total, there are 21 animals, my lord. A day, I am incurring more than 4,200 rupees for them, my lord. And my lord, this state government is under legal obligation to pay this amount to me. Now, my lord, from July onwards, if my lord sees the court's order, kindly come to the court's order, my lord. At page number, it's a registered association, my lord. I have enclosed those. Kindly come to first order at page 24. This is of 5th July, my lord.
Yes.
My lord, I am not reading the entire order, my lord. Kindly come to the operative portion, my lord. Page 25. That the prayer of the IO for handing over the seized 14 cattle to the NGO, namely Crusaders Against Animal Suffering at Ashmatabad, Port Blair, for their safe custody, be and the same do hereby stand allowed. The IO will affect the transportation of the seized cattle and the expension for the same shall be borne by the police department. Let copy of the order be sent to SHO. Let a copy of the same be sent to the General Secretary, so and so, so and so. The case is pending, my lord. If my lord sees page 25, first paragraph, last line, during the pendency of this case. Now, my lord, in terms of this order, these cattle were handed over. One more order is there of page 26 of 11th of July 2023, whereby again, my lord, if my lord sees the operative portion, my lord, 8 cows were handed over, my lord.
Yes.
My lord, I have made repeated representation before the authority. From page 30 onwards, I made representation before the Honorable Lieutenant Governor.
For disbursal of the amount.
Yes, my lord. Thereafter, Chief Secretary, I met the Deputy Commissioner. Deputy Commissioner said me to write a letter to the Deputy Commissioner North and Middle because it belongs to North and Middle from where it was transferred, my lord. Ultimately, my lord, it is more than 2 months, my lord, till date. I did not receive, and I am at my own expenditure. I am doing this, my lord. Kindly consider this, my lord.
Yes.
So representation considered within a time limit can be given to the DC, my lord.
And paid within a time limit, not consideration.
But paid, my lord, but they have to check whether the DC also animal husbandry or not, whether the DC or animal husbandry. Let it be, my lord, for representation consider, I think, my lord, they are going to do something, my lord. Because today morning I have only received the brief, my lord. I don't know whether the animal husbandry or the necessary.
My lord, in the light of that order which was
Yes, yes.
sent by the ministry, my lord.
Yes, yes, of course. The petitioners the first petitioner, who is a registered society comprising animal lovers and represented by the second petitioner herein, was given possession of how many cattle?
21, my lord.
21 cattle
Actually 22, my lord. One died.
One died.
21 I am right now.
by an order. Or let me record it, 22 cattle by an order passed by the Chief Judicial Magistrate, by orders passed by the Chief Judicial Magistrate Maya Bandar on 5th July 2023 and 11th July 2023 respectively, in UR case number 258 of 2023 and 196 of 2023. Put the respectively here, respectively, not strike out the earlier one. Out of the said cattle, stop, comma, one expired. This is a notification or an order?
My lord, this is
Page 28?
my lord, I am giving this copy is better one. My
Better.
lord. Yes. My lord, this is a letter written by the Animal Welfare Board, which is a statutory body, to all the chief secretaries of state and
By a
UPs.
letter issued by the Animal Welfare Board of India to the Chief Secretary of all the states and union territories of the country on 3rd May, 2018, comma. The authorities were informed about the notification of the central government for prevention of notification of the central government on prevention of cruelty to animals within bracket marketing and care of case property bracket closed rules are capital 2017 for maintenance of animals seized in violation of the act and rules. The rate chart shows, the rate chart indicates that rupees 200 per day per animal is to be allotted for daily maintenance and care of large animals, comma, cattle, the cattle in possession of the petitioners being under the category within inverted comma, large animals. Paragraph. Learned counsel for the petitioners submits that despite the said letter, comma, no fund has been received by the petitioners for the last 2 months.
Thereafter, my lord, I have given several representation, but despite of that, till date, they have not given any fund.
This is 3rd May 2018. So you have not received it at all.
No, my
The
lord, it
funds-
will be received. No, I have not received. It will be received only as and when I have been handed over with the said cow as an interim measure by the court. This is the first time perhaps this was.
Despite such letter, no fund has been received by the petitioners from the administration till date. Stop. Several representations submitted by the petitioners in this regard have fallen on deaf ears. The petitioners seek a direction upon the authority to consider the representations submitted by them in the light of the letter issued by the Animal Welfare Board of India on 3rd May 2018. Paragraph. Learned counsel for the respondents submits that who should be the authority to consider?
No, said it is the deputy commissioner will come under the deputy commissioner North and Middle Andaman since
Third respondent.
third respondent. My lord.
The third respondent will be directed to consider the representations in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representations submitted by the petitioners. How many representatives? 2 are there?
Who are there?
We are there from 2018 to 2023.
My lord, page 33 is the
Very-
representation made to respond number 3.
So let this be disposed of.
My lord.
This-
In the light of
consider
that,
and- Of course, consider and dispose of the representation submitted by the petitioners dated 8th September 2023. Within
4 weeks.
No, my lord.
But this,
Within a week, my lord. My lord, kindly see, it's a good cause, my lord.
4 weeks.
No, my lord. My lord, kindly appreciate the situation, my lord. It's for good cause, my
3
lord,
weeks.
they are doing.
3 weeks, then
No.
3 weeks.
3 weeks. Within 3 weeks from the date of, because Dasara is
My lord.
approaching, from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioners, comma, in accordance with law, in the light of the observation made in the letter issued by the Animal Welfare Board of India dated 3rd May 2018, comma, in accordance with law.
My lord, if after considering the representation, they found it fit, my
It
lord,
is-
then
yes,
immediately,
yes,
otherwise it will not be.
Event paragraph, in the event the representation is decided in favor of the petitioners, comma, the said authority shall take necessary consequential steps immediately thereafter.
I think it needless to say that they are definitely they are.
No, it's required.
No, sir, it doesn't always happen. You are aware.
Oblige.
Next,
My item number, my lord, 9 and 10, my lord, I am saying, my lord, because my lord, yesterday evening I have received, does not have received any information.
next.
No, not next circuit, my lord. Tomorrow I
Look
am
at
seeking,
tomorrow and day after will not be.
I am seeking for an interim order. This is first time this is appearing, my lord.
Let it be, my lord, tomorrow, because forest matter is that tomorrow, they have
Tomorrow.
forest matter. Forest. So that order will also going to affect this.
No.
order.
That is.
Not today,
Get.
9 and 10 both.
Item 20, WP 8453 of 20.
20, I am appearing for the petition, my lord. Shiva Balan is appearing, opposing me.
Where is he?
Let it be in the next circuit then.
None appears for the respondents. The paragraph, the matter be placed before the next available circuit bench.
My lord,
It's a lengthy matter.
my lord, sometime.
Right. That's all.
I would like to mention one particular matter because I
item number 7 of court number 2 was delisted and it was supposed to be listed tomorrow. I'm just mentioning, it may be
Listed,
at the top of.
not at the top, it will be listed.